Good afternoon, everyone. This is the regular scheduled meeting of the Complaint Committee of the Sunshine Ordinance Task Force, scheduled for Tuesday, September 14, 2010 at 3:30 p.m. and beginning at 3:30 p.m. I am James Kneber, and to my left is Richard Nee. Could you call the roll, please?
Yes, Mr. Chair. Member Nee?
Here.
Nee present. Member Washburn? Washburn excused. Member Kneber?
Here.
Kneber present. Mr. Chair, there is a quorum.
All right, thank you. Can you call the first item, please?
The first item is the approval of June 8, 2010 regular meeting minutes.
Move to approve.
Second that. Any comments, public comments on the minutes? Seeing none, can we have the vote, please?
On the motion, Member Nee?
Aye.
Nee, aye. Member Kneber?
Aye.
Kneber, aye. Mr. Chair, there are 2 ayes.
Thank you. Can we call the second item, please?
Item number 2 is the approval of August 10, 2010 regular meeting minutes.
Move to approve.
I second that. Can we have the vote, please?
Public comment.
Oh, is there public comment on the motion to approve the amendments for August 10th? Seeing none.
Mr. Chairman, there are a couple of corrections here. One of them is substantive. In the roll call where it says excused, it lists Johnson. That should be Kneber. And also on the second page, which is page 9 in our packet, under item 4, there should be no, the word on should be stricken.
Okay, so the motion is to approve the amendments as amended.
As amended.
Okay, second, okay, is it? Can we have a vote, please?
On the motion, Member Nee?
Aye.
Nee, aye. Member Kneber?
Aye.
Kneber, aye. Mr. Chair, there are 2 ayes.
Thank you. Can we have the third item, please?
Item number 3 is the determination of jurisdiction on complaint filed by William and Robert Clark against the Mayor, the Board of Supervisors, and the Arts Commission for passing an ordinance that allows the Arts Commission to charge a fee to process public document requests.
Thank you. Is the complainant here? Could you repeat his approach? You will have 5 minutes to show us why you think this, the Sunshine Ordinance Task Force has jurisdiction. This is not about the merits of the case. It is merely about the jurisdiction. Hold on.
My name is William Clark, first of all. In the Sunshine Ordinance, it states, I believe, under section 67.26, that the work of responding to a public records request and preparing documents for disclosure shall be considered part of the regular work duties of any city employee, and no fee shall be charged to the requester to cover the personnel costs of responding to a records request. And in 67.28, it says no fee shall be charged for making public records available for review. Well, recently, the Art Commission proposed a fee increase of the street arts fee by $47.44 to pay for Art Commission staff time and city attorney staff time to process public document requests made by the public and street artists. And this was based on the fact that couple of years earlier, I believe 2 individuals had requested numerous public documents requests, and an amount of time was needed by the director of the program to process those complaints, those requests. And what happened was that at their meeting and at the, I would like to read Mr. Kinsell's, the head of the Art Commission's testimony at the Budget Committee as to why this fee increase was necessary. It's pretty short. He stated, and I have the DVD of this that I also can present to you. He said the need for this increase is over 2 ordinances in city policy. And when the street arts program was established by the city, it was determined that it be cost neutral to the city. The Arts Commission always does a careful job looking at what it costs to operate the program, and is it operating from the revenues it generates from its fee. The second is the Sunshine Ordinance. When that was passed, it required the Arts Commission to respond to requests of information regarding the operation of their programs. Unfortunately, in the last 2 years, we have seen a small number of individuals abusing the Sunshine Ordinance rules, requiring small groups to spend an inordinate amount of time responding to questions, responding to documents, etc. From 2008 to the current fiscal year, the number of hours that the Street Arts program had to spend doubled with respect to the number of requests dealing with Sunshine. In addition to staff time, you have the city attorney's time that would be paid for. That is the reason we are seeking a $47.44 increase to help pay for additional part-time staff to help comply with the Sunshine. I assert that Mr. Lazar has not been going by the proper requirements of the Sunshine Ordinance. What he's been doing is whenever there's been a request, instead of either giving the request out or denying it, he's been sending every single request over to the city attorney for the city attorney's advice and opinion, which takes up time of the city attorney, when the Sunshine Ordinance states the process is that if he doesn't believe something is public that should be released, then it's up to the requester to request from the city attorney whether or not these documents should be released. And that's something that needs to be straightened out. And as a result, what's happened is, that, like I said, the Sunshine Ordinance says that it's every employee's job, regular job duty, to process document requests. And therefore, we've been paying for 2 employees, full-time employees at the Arts Commission level, and recently, since February, we've only had 1, and we've been budgeted for the full second-time employee. And what they're requesting is for a part-time employee to be hired to pay for processing these documents when they don't even have a second full-time employee hired. And as a result, there's something like $90,000 in the Street Arts Special Fund at the present time that could cover any additional costs that the Art Commission may need. So basically, I'm asserting that this fee is a backdoor fee. I've already paid $11 and I believe 86 cents so far to pay for this expense, and I have yet to, I haven't asked for any documents, and I believe this is a backdoor method of discouraging street artists from asking for these documents, because we are trying to find out some information about how our funds are spent and what our budget is and all these things, and we're having a difficult time getting that information. That's basically my reason.
Thank you very much.
This is my brother. He's
Okay.
the other complainant.
Okay, thank you very much.
Yeah, I want to address the.
The complainant's time is up, and you're a named complainant, so I think.
My name is Robert Clark.
Yeah, but it says both of you are named complainants, so your time is complete. You will have time to rebut in a few minutes, so that you can come back up.
Thank you very much.
Okay, thank you. Do we have the respondent here?
Facts and evidence.
Oh, I'm sorry. Is there anybody here to support the claimant with facts and evidence? You are a complainant, sir. I can't have you come up. All right, seeing none, can we have the respondent, please? You have 5 minutes. And just to reiterate, please focus on the jurisdiction in this case. Thank you.
Good afternoon, members. I'm Howard Lazar, Street Artist Program Director for the Arts Commission. And we're saying that the task force should find that the respondents have not violated the Sunshine Ordinance. The administration and enforcement of the Street Arts Ordinance, in turn, it includes but it's not limited to doing the job of managing and enforcing the Street Arts Ordinance, which is reviewing and processing street art certificate applications, managing the budget issues, issuing street art certificates, et cetera, et cetera. It also includes the processing of public records requests regarding the street arts program from any individual and not just certified street artists. Before submitting its budget to the Board of Supervisors with a recommended fee increase, the Arts Commission's Street Arts Program determined that a fee increase was necessary in order to cover the costs of administering the program, including but not limited to increased staff salary and benefit costs, enforcement costs, as well as additional administrative costs arising out of processing and responding to public records requests. Now, I'll get to the real heart of the issue here. We do understand that the Sunshine Ordinance precludes the city from charging a requester for its costs associated with processing a public records request and for the requester's inspection of records. And we understand that it authorizes departments to charge certain fees to the requester for copies of records, and that's what we do. But the Sunshine Ordinance does not prohibit the city from setting a permit fee based on the cost of administering a permitting program, or in calculating that fee from including the costs the department incurs in complying with public records requests. If a department were to charge a requester a fee to cover the personnel costs of responding to the requester, then the task force would have jurisdiction to determine whether the department had violated your section 67.26 of your ordinance. Similarly, if a department were to charge a records requester for inspecting a record, the task force would have jurisdiction to determine whether the department had violated your section 67.28A. But those facts are not present here. Furthermore, nothing in the Sunshine Ordinance remotely suggests that the task force has jurisdiction to determine the legality of permit fees charged to street artists, or for that matter, the legality of fees charged for place of entertainment permits, taxi permits, or building permits. Challenges to the legality of permit fees are properly brought in a court of law, not before the task force. And so, finally, I just wish to add that the task force should dismiss this complaint for two major reasons. Number one, the task force lacks jurisdiction to adjudicate the complaint. Number two, the complaint does not state a violation of law. The task force may not judge the legality of an ordinance which sets certificate fees for street artists or any other category of city permittees, and therefore should neither assert jurisdiction over the complaint nor find the complaint to be legally valid. Thank you.
Thank you. Is there anybody here to support the respondent with facts and evidence? Seeing none, the matter is with the committee.
This is it's a tough one, I must say. I must say. I think both sides have some very good arguments here. I'm not sure. I'm not sure that the relevance, the jurisdiction is lacking. I think. I agree with Mr. Lazar that setting of permit fees does not fall within the Sunshine Ordinance. However, there is, I think, a question of the motivation for setting those permit fees, and I think that could be something that would be discussed if the merits of the complaint came before the task force. So, balancing those two, I'm inclined to support jurisdiction without prejudice to the actual merits of the complaint. I think those could be weighed more fully before the full task force when we do look at merits.
I tend to agree. Just looking at this, when I try to separate the merits of the case out, the actual subject matter, I think I would lean towards finding jurisdiction, irregardless of the facts of the case brought by both sides. So I would lean to that when we get to there. So now is the time when we can take rebuttals. The first will be from the respondent to make. You have 3 minutes if you wish from the respondent first to make a rebuttal. Any clarifications if you wish.
No, I'll waive that. Right.
Okay, thank you. So now the same for the complainant. You have 3 minutes.
My name is Robert Clark. I just want to read section 67.28, which says no fee shall be charged for making public records available for review. Doesn't mention anything in that statement about a specific person asking for a specific document. I also want to make it clear to the hearing officers here that Proposition K, which gave authority to the Art Commission to raise fees, included language, and it was a ballot measure, and it was an initiative measure, that said when necessary. It included those words in the law itself. And what is happening here is on December 19th, the controller told the Art Commission through an email, which we presented to this committee, that told Howard Lazar that there was over $30,000 in surplus in the Street Artists Fund, and therefore had enough money in the old fee to cover the $18,000 that they were requesting to charge us with the new fee. Therefore, the Art Commission did not have the legal authority to raise our fees because they already had over $30,000 in surplus. And I want to make that clear because we believe that Proposition K only allows the Art Commission the authority to raise our fees when necessary. Thank you.
Thank you. No, you've already passed over your right, sorry. Back to, now we'll entertain public comment. Public comment on, I'm sorry. I will entertain a motion on this matter.
Move to find jurisdiction.
I'll second that. I will, now as part of the process where public comment, any member of the public who wishes to make comment on our motion or the discussion may do so now. Seeing none, can we take a vote, please?
On the motion, Member Nee.
Aye.
Nee, aye. Member Caneba.
Aye.
Caneba, aye. Mr. Chair, there are 2 ayes.
Okay, thank you. This motion carries, so this complaint will be heard at the, which one, Chris? Is it this
September 28th.
Is it 28th? This complaint will be heard at the September 28th meeting of the Sunshine Ordinance Task Force at 4 p.m. Thank you.
Room 408.
Excuse me?
Room 408.
Sorry, room 408. Could we have the next item, please?
Item number 4 is the determination of jurisdiction on complaint filed by Randall Evans against Mo Magic.
Is the complainant here? Please approach. You have 5 minutes to explain to us why you think the task force has jurisdiction.
You had jurisdiction before we had the same complaint in front of Mo Magic, and I just want to make something very clear. Mo Magic right now is on the corner of Eddy and Fillmore. The Unfinished Agenda Corporation mobilizes and works right in that area. We've been in and out of their office. We have attempted to do business with them before, and it's just a crying shame that we have to come all the way down here just to get what Barack Obama is asking everybody to do, to be transparent, to get information, to find out what's what out there. Now here, Mo Magic is going to probably stand up here and say they're out there doing all this kind of work in the community, don't need to be down here wasting their time. I stand here saying the same thing. Just left work, took off early. I'm a president of a corporation called the San Francisco African American Unfinished Agenda Corporation. It stands for everything to be unfinished out there. Now, if you're working in a community and you're receiving funds and you're out there functioning in order to be transparent, then why are we here? That's why I'm here today. I've asked them for simple information. I've done it before. They did not comply, and one of the reasons why I withdraw my complaint, because at that particular time, Jeff Adashi's office had me involved in a case that I finally got dropped from the court cases, so now I can come back and try to get the same information so that we can have community meetings and be transparent. Thank you.
Thank you. Is there other parties for the complainant to present facts and evidence? Seeing none, is the respondent present? All right, you have 5 minutes to speak to why you think we have jurisdiction or not.
So to clarify, when we were here before and the request was withdrawn, that was actually made.
I'm sorry, state your name, please, for the record.
Cheryl Davis. that from MoMagic. And so I work for the Public Defender's Office, but I work to do collaboration or convening to do things on behalf of the community. When we were here before, the complaint was against the Public Defender's Office. He actually released the information, even though the request was withdrawn. You did have the information that was requested specific to my salary and that information. The request was withdrawn. This complaint is actually against MoMagic, which is not a formal 501c3, does not get any money of itself. It works with partners in the neighborhood. It convenes different organizations. Money that comes through actually goes to the partners. The partners pay the money. They pay the bills. They do all these other things. I get reimbursed for money that I spend. And all the grants and monies that we have, even through all of our partnerships, which are a combination of foundation grants as well as city funds, are less than $250,000 a year. So based on the monetary amount, which again doesn't go to any one entity, but based on the monetary amount that supports the work of MoMagic, it's less than $250,000. That money does not go to the Public Defender's Office. The Public Defender's Office pays the salary of me. I convene monthly meetings and I work with people in the community. The money goes through other organizations and it's less than $250,000. We do put out an annual report. We do have information that shows where our money comes from. We give that information out at meetings. We actually started that last year when we were brought here before, or whenever that was. We actually did an annual report. Those facts and figures are in there, but in regards to being able to get the vendor information and all that kind of specificity, it actually wouldn't reside with us because we don't do the audits and all those. Those go through our partner organizations.
Thank you. Is there anybody else here to present facts and evidence in support of the respondent? Seeing none, the matters with the task force.
I'd like to ask Ms. Davis a question, please. Thank you for coming. You said that that MoMagic gets less than $250,000 from the city. Could I ask how much MoMagic does get?
Last year we had 3 grants from DCYF and 1 from the census, or from the Office of Civic Engagement.
How much does it get from the city?
So that was about $150,000.
$150,000. Do you have any kind of a contractual agreement with the city?
I do not.
Does MoMagic?
No.
Okay, so there would be no kind of a provision whereby MoMagic would agree to abide by sunshine because there is no contract,
No,
correct?
because our contracts the contracts that the city has are with partner organizations because we're not a formal nonprofit.
Okay, thank you.
I would entertain a motion. Well, I think you motions first on here.
3-minute rebuttal.
Yeah, okay. Okay, so now it's time for the respondent. If you have anything to add or rebuttals, you have 3 minutes.
So I just, I understand about transparency, and again, I'm an office of one, and we do a lot of work. We had some jobs now, people. Here's the reality, that I agree that there's certain information that should be out there, but I also do not think information should be released just for the sole purpose of people being harassed. I think that this is about, if this is really about getting the information, again, the numbers, if anybody wants to have the numbers of how much money is coming in and how the money is being put out, that is actually available. It's out there. I can give that. But, I do want to say, in terms of when I was given the information for this, it was during a time when we were actually going through some other legalities, and somebody brought in a paper, threw it at my desk, and said, "I'll see you in court." I actually thought it was something else and didn't, initially respond. Otherwise, I would have sent a letter at that time. So I just really want to stress that if we were under contract and had to abide by sunshine as MoMagic, we would do that. But we work with about 5 different organizations who actually sign the contracts, and those executive directors manage the funds. So I just wanted to say that.
Thank you. Now it's 3-minute rebuttal.
I want you to be very careful for what she says, and you cannot take this serious or do. First of all, it wasn't just anybody that walked in there. I walked in there. I gave this lady a copy of the Sunshine Orders, and I do believe that her 501 that she's with, she has a what you call a fiscal agent at the Cultural Center, okay? She sits and be in charge of all that money that she says she's not about in the community. She sits there and delegate authority, and Jeopardashi also does as well. There is no such thing as no harassment. What I call harassment is when people come into the community claiming to look after our children and our community events and all these so-called partnerships, which she claimed is only under $250,000. She sits at the top of the desk where over 20 or 30 different organizations comes into a room at the Culture Center, which is their fiscal agent, and they talk about dollars and cents. I think it's a grave insult for her to stand up here and think that that's harassment. Her wildest dreams don't know what harassment is when it comes to harassment. This has nothing to do with harassment. It has to do with exercising our rights of finding out information when you sit in a community in the middle of economic problems that we have here and call yourself determining whether or not people move or groove in there. Now, if she don't feel like she's under that jurisdiction, then we'll find another way to get information. But without a question of a doubt, when she talk about these 4 or 5 organizations, these are people that come from all around the city, sits at Mo Magic meetings, and now she says all she merely does is coaches where the money go. All right, thank you.
Thank you. Now the matter is back with the task force.
Mr. Chairman, before I make a motion, I'd like to make a comment regarding this. Ms. Davis's remark on both her remarks on the harassment question. I think it behooves the respondent especially to be very careful about that, because a respondent to a request is not allowed to ask or assume purpose. You know, if there is a harassment fear, then the respondent has, of course, the right and perhaps a responsibility to take appropriate steps, such as contacting security. But in terms of what motivates a sunshine request, routinely asking or guessing, that is out of bounds under sunshine. Having said that, however, I think jurisdiction here cannot apply because the respondent, Mo Magic, does not get the minimum $250,000 from the city. Therefore, I move to find no jurisdiction in this complaint.
I would have to agree. I had some reservations until I heard Ms. Davis, but I think that I would have to agree and second that motion. Now the matter is for public comment. Any comment on this case?
Hi, my name is Tina Collins, and I've been around since Mo Magic has been in existence. I'm an activist in the Western Addition, and with the assistance from Mo Magic, I stay in Plaza East, where there were multiple killings 4 or 5 years ago. And through the assistance with Cheryl, a lot of that stuff has cut out. We have no more killings in Plaza East. We have youth that were not going to school, that are in school, that come to the office on a daily basis. They are necessary. Like right now, they are not doing nothing, but they still come to the office. They come in the office, sit down to do their homework. They find that's a comfortable place to be at. I too, well, I don't know how to put it, but I too was in that room when that paper was thrown to the table. And it wasn't given to her, it was just thrown to the table. And me and another lady was there who also was doing volunteer work. So I move around the community and talk to different mothers and stuff, and sometimes people like to want to come help. So I may have one person helping me 1 week, another person helping me another week. But all my stuff that I do for volunteer services. At all the hours, I put over 40, sometimes 50 hours a week at Mo Magic. I have a teenage daughter, and I also have 2 children that are 8 and 6. And I find that that's a comfortable place for them to be at. And I also are able to bring other children out of the community whose parents are not really involved, but they're at home, bring them where they can have a program and get some self-sufficiency about their self.
Okay, thank you. We have any other members of the public who'd like to make comment? You have 3 minutes.
My name is Dan Solberg. I'm a member of the Unfinished Agenda Corporation. Clearly, the operations of MoMagic have been well known and well publicized. My concern is that in the matters of public disclosure, that MoMagic, although it acts as in public as a corporation or as an entity, as an agent, as a group, as a nonprofit, it may not have the particular designation legally of a 501c3. I'm not sure that that has been made known clearly. They have a website. They have all the appearances of an entity and operate under that guise. My concern is that the disclosures that would come as a result of acting as an agent or as an entity are basically made opaque for the very reason of being able to step back and say, well, it's only a collaborative, it's only a collective agent, namely one person. I find that a little distressing, a little difficult to understand. The issue of transparency now would then, if there is no jurisdiction in this particular case, given the circumstance, would require the public then to pursue every and all other entities which collaborate under one entity, namely Cheryl Davis. It's not really MoMagic, it's Cheryl Davis. And I find that a little disconcerting for public access. So my urging would be that jurisdiction would be exercised here, given the fact that that not only does MoMagic, Cheryl Davis, have a physical agent, but also collects and solicits funds from public agencies that are part and parcel of providing this kind of service to the community.
Thank you. The matter is back to the task force.
Further public comment.
Oh, I'm sorry. Is there any further public comment on this issue? Seeing none, members, the matter is back with the commission for a vote. Any further comments, Ben?
Just one, and that is the fact that the task force appears not to have jurisdiction in this matter for legal reasons. The Sunshine Ordinance and particularly Section 12L of the Administrative Code set the $250,000 floor. So in declaring that we find no jurisdiction, the committee is not saying that the complaint itself has no merit. We're not weighing that. We're not saying it does. We're not saying it doesn't. We are just saying that we find no jurisdiction. In addition, this matter will be reported to the full task force, and certainly the complainant and the respondent both have the right to go before the full task force and ask that the task force overturn the recommendation of the committee. Mm-hmm. You have that right. So the task force, we are voting. The committee, this committee is voting on the jurisdiction question right now. The task force's next meeting, regularly scheduled meeting, is September 28th, 2 weeks from today. You have the right to contact the clerk of the task force, contact the chair of the task force through the clerk, through the administrator, and ask that this matter be placed on the agenda for further consideration of the committee's recommendation. When the committee report is given, which will come toward the end of the agenda of that meeting, when the committee report is given, you will have the right at that time to address the full task force and ask that the committee recommendation be reversed.
All right, thank you. Can we have the vote, please?
On the motion, Member Nee.
Aye.
Nee, aye. Member Knepper.
Aye.
Knepper, Mr. Chair, there are 2 ayes.
All right, this matter is closed. Can we have number 5, please?
Item number 5 is determination of jurisdiction on complaint filed by Joseph Victor Lagana against the police department for not releasing computer-assisted dispatch records.
Is the complainant here? Yes. All right, please approach. You have 5 minutes to give us your reasons for why we should find jurisdiction in this case.
Okay, the police department is a charter department under the ordinance. The task force therefore has jurisdiction to hear the complaint against the department. Also pursuant to Marbury versus Madison, the province of the court is solely to decide on the rights of individuals. Questions in their nature, political or which they are, by the constitutional law submitted, the executive can never be made in any other court. So therefore, this court has jurisdiction. I have been asking for these records directly through the SFPD on my own. They deny the fact that they ever received such a request. And I have here, if I can pass it on to you as an exhibit, if I can just have one back, you can keep the other 2. But as an exhibit showing that I have requested these documents through the city attorney's office, and their attorney continuously denies what he knows what CAD transcripts are, and SFPD legal department says he should know what CAD transcripts are. This is public record. I get the police reports, but I continuously denied the CAD transcripts, probably because it shows the vicarious liability on the city, that these officers are lying. And that's withholding evidence, which is public knowledge. Everyone else gets their CADs, why don't I? It's already been 2.5 years. As to a case of arrest, June 13, 2008.
Okay, thank you.
Yep.
Is there anyone else here to provide facts and evidence in support of the complainant? Seeing none, is the respondent present? You have 5 minutes. Remember, we are determining jurisdiction on this matter alone in this committee.
Yes, good afternoon, committee members. My name is Simon Silverman. I'm a lieutenant in the San Francisco Police Department, and I'm the commanding officer of the legal division. The department doesn't dispute jurisdiction, but it may be useful to clarify that in this case, we don't believe that the San Francisco Police Department is the correct respondent city agency. Computer-aided dispatch reports are maintained by the Department of Emergency Management and not by the police department, and therefore, because we're not the custodian of this record, we're not the appropriate respondent.
Thank you. Is there anybody present to present facts and evidence in support of the respondent? Seeing none, the matter is with the task force.
I have no questions.
I have no questions either. I am looking specifically at at the jurisdiction question and not at the merits of the case. So I'm leaning towards jurisdiction on this, but that will be saved for later. So at this point in our proceedings, the respondent has 3 minutes to rebut or to clarify anything else that they think needs.
Yes, sir. Again, we don't dispute that that the Sunshine Task Force has jurisdiction. Our concern is that it's not an effective use of the Commission's time to bring the wrong respondent up here. Because if we were to come back for the full task force, my answer would be the same. We're not the custodian of that record. So I'm a little bit at a loss. While I don't contest jurisdiction, I understand that part of the purpose of the hearing is also to clarify the complaint, and perhaps in clarifying the complaint, it might be more effective to have someone from the Department of Emergency Management present.
Okay, thank you. The complainant has 3 minutes to rebut.
According to the SFP Legal Department, the City Attorney's Office, they will needlessly delay this as long as they need to. The Emergency Records Department, I contacted them. My problem is not with them because they said that they could try to work it out. This is delaying evidence. This is withholding evidence, and they cannot delay this any longer. I've already filed in the United States District Court, if you want to look at the complaint, about this needless delay and of withholding evidence, and this is obstruction of justice. They want to delay this as much as they can. You know, eventually it's going to come out. So why do they keep delaying it? I've talked to the Emergency Records Management Department. They said that those records will be maintained, but regardless of that fact, I'm bringing them here because they are withholding evidence. It's not about jurisdiction, this and that, or whether or not who's the right custodian, okay? They have those records, I'm sure. He's sitting here trying to delay this. Needless delay of the court is actually sanctionable. If this was a court, that would be a sanctionable thing. Okay, that's all I had to say.
Thank you. The matter is back with the task force for motion deliberation.
Move to find jurisdiction.
I tend to agree. I second that. Do we have public comment on this motion? Seeing none, the matter is back with the task force for a vote. Can we take the vote, please?
On jurisdiction, Member Nee.
Aye.
Nee, aye. Member Knebber.
Aye.
Knebber, aye. Mr. Chair, there are 2 ayes.
Thank you. This complaint will be heard at the September 28th meeting of the Sunshine Ordinance Task Force at 4 p.m. in room 408. Is that correct, Chris?
That is correct, Mr. Chair.
Can we have item 6, please?
Item number 6 is the administrator's report. Mr. Chair, we have only 1 complaint as of today for the next meeting.
Okay. Thank you.
We'll keep our fingers crossed.
Okay. Please read item number 7.
Item number 7 is public comment on items not listed on the agenda.
Is there anyone present who wishes to make public comment on any items not listed on the agenda? Seeing none, move
Move to adjourn.
I second that.
So move.
The rise and vote.